For those of you who weren't in the room, my name is Coogan. I'm with the Department of Jobs, Enterprise and Innovation. I work in the company law unit and I am one of the people behind the Companies Act 2014, the current regime of company law in Ireland. We commenced the legislation on Monday last. And in a rather unusual step, we commenced almost all aspects of it. There's really only about 5 sections that weren't fully commenced. So it's actually fully operational now. So you have this vast volume here, and yes, we're all agreeing that it's very handy, it's all in one place. But really you must remember that depending on whatever issue it is that you're looking at, does not mean you have to read the whole Act for everything. So if you are dealing with, say, as I said, Part 6, that is, you're looking at your filing requirements, and this is basically informing the CRO, and not only the CRO, because the CRO puts this information then onto the public record. So what Dr. Murphy was saying to you is, say you want to look up Coogan Limited, not that that body, as far as I know, exists, but should there be a company like that, you put in the name Coogan Limited, or maybe I have a business name, you put that on, and you click on that, and the CRO register will tell you all the companies with that name that exist in Ireland. And then if you need any further information, you will see they will give you an identifier number, and it will also give you information such as whether the company is still active or is it dormant, if it's been struck off, whatever, dissolved, whatever it may be. If you then need further information, you can click on that link and you can pay, I think it's a fee of €15, and you can buy information about that company. So you can actually get my financial accounts from the CRO. Now you might say to yourself, well, why would I want to know that? Well, if you were entering into a business arrangement with me and you were giving me credit as a business or as a third party, you might want to know what my financial situation as a company is, because remember, you're not dealing with me, you're dealing with the company, the limited aspect. So that's where that information is, and that's why the CRO is an extremely important resource, not only for you as a company, but also if you are interacting with companies. So Part 7 is not something I'm going to spend a lot on. This is quite a technical area, but effectively it relates to a situation where a company borrows money, or whatever it may be doing, it may be getting credit. Usually what is then created is a charge, and there's a floating charge and fixed charge, and I'm not getting into any of that. That law remains as it always has been. But what now has been settled in law under the Companies Act is that if you have a charge against a company, i.e. they owe you something or you have a claim on something that the company owns, you must register that charge. You must inform the CRO that you have this charge, and the minute that registration is recorded by the CRO is the date of which your charge will have priority. Now, this is a technical piece of law, but effectively, if a company goes into liquidation or a company is about to go bust, the reality is all the creditors will start accumulating. They all want their money out of the company, obviously. The priority is given to taxes. In Ireland, every taxman will always get their first cut. Employees will get a certain amount. And then priority of charge will dictate who collects next from the pile, whatever is left. So it is important, if you do lend to a company, or indeed if you are entering into a transaction where there is credit or anything like that involved, that you check what the credit situation is. So you will get an idea of a company's fiscal health, if you like, from this. This is a public information. But if you do not register, if you yet again lend money to a company, now yet again, it's unlikely that any of you would be in that business, but if you were, you lend money to a company or you gave them credit and you kind of said to them, well, look, I'm going to give you a line of credit for a period of time, but you know what, I'll fix, you know, say that machine that you have there. If you can't pay, that machine is mine. If that kind of situation is there, you need to make sure that it's registered, because it is the date of that registration, not the date that you entered into the agreement. It's the date when the CRO was notified that this arrangement has been made. That's something new under the Companies Act. And yet again, we've just wanted to remove all the uncertainty about when does a charge kick in? When is it fixed, so to speak? Now, don't know if it works. Is it working there? Yeah. So I don't want to go into that. Now, receivership law then, Part 8, is effectively the law has remained the same. There are some changes though. Effectively, the only things that have happened now is that the duties of the receiver and the powers have been set out in statute law. These are not new, but it is the first time that they're set out in statute law. Otherwise, the law very much remains untouched. And the reason for this is that whilst you may be aware that receiverships have become quite controversial in certain circumstances, receivership is about contract law. A receivership is something that arises when you and a company and a third party has entered into an agreement, usually in lieu of money or some other asset, and it's agreed that, look, you either pay me back or I claim an asset of your company, or I'll claim something. And these are contractually agreed. So we as a statute body do not want to interfere with that contract. So this area remains very static. Mergers, reorganisations, acquisitions and divisions is not an area that I'm going to go into very much. The law here remains quite the same. The big difference here is obviously that SAPs can be used, but also what used to be only applicable was if an Irish company merged with a non-Irish company. So if you were doing a cross-border merger, there was a very useful regulation set out in European Union law for that type of procedure. We've now introduced that procedure into national law so that if you're doing a merger, so that's if two companies, for whatever reason, decide to come together and form one legal entity, this is the part of the Act that would be applicable to you. Examinership law, yet again, an examinership is a unique situation where a company is going through difficulty, but there is an idea that there is a prospect of saviour, that if you reorganise, if you kind of put certain measures in place, the company can be rescued. And what you can do if in an examinership period is you go to the court and you ask the court to give you protection from your creditors for a period of time, it's 70 days, during which you try and fix your company. You try and come up with a solution that allows your company to get through the difficulty that it is undergoing. The law here hasn't changed. I will just mention to you because it was new. In 2013, we introduced a provision in a miscellaneous provisions bill that was, or act, which was done before the 2014 Act, that allows small size companies, so these are yet again companies with a turnover of less than 8.8 million, and less than 50 people working for them, to use the circuit courts rather than the High Court to seek examinership provisions. The rationale here is that circuit courts obviously serve you in your area, and also the costs are arguably less prohibitive. So this has been highly welcomed, and we believe at the moment there's about 26 or 27 examinerships that have been heard or are being heard in the circuit court. So we're looking to see whether this is beneficial in the long run. Now, winding up effectively here, yet again, the law remains very similar. So winding up is a situation where shareholders or creditors or somebody decides this company needs to be wound up, it needs to cease to stop being a company. And effectively what the innovations here are is that we have introduced similar procedures, whether you're doing it voluntarily among yourselves as a company or whether the court is involved. The idea is that most of liquidations now would be done by company on its own without court involvement. Now, obviously, that is only something that is possible when there are no angry creditors or people left outside the loop. But when you have a healthy situation where a company, for whatever reason, just decides to wind up, these procedures are available there. And also, I suppose, a new innovation in this particular area is that we have introduced a requirement that if you want to call yourself a liquidator and you want to act on behalf of a company as a liquidator, or indeed an examiner, you must be now appropriately qualified. It has been very interesting that until the big economic difficulties that we had in Ireland in the last while, there wasn't many liquidations going on really. But then all of a sudden, you know, people were appointing their grandmothers and everybody else to be liquidators, and there has been some suggestions that there has been some serious dishonesty involved, that liquidators have hidden assets and so on and so forth, so that when then creditors have come looking for their fair share, the company has been stripped bare. So effectively, you must be appropriately qualified, and there is also what we call a grandfathering provision recognised here. So if you are currently a person who's involved in liquidations and you are not a qualified solicitor or a qualified accountant or third country qualified person, then the reality is you can seek to be recognised to be a liquidator by EASA, which is a regulatory body. And this is the idea, is that after a period of time, we will not have this category 5 persons anymore, And effectively, if you want to act as a liquidator, you have to be either a qualified accountant or a solicitor, and you must have indemnity insurance. And this is a big introduction. Until now, you know, anybody could be a liquidator. Now the court will be asking you, before they appoint you, to satisfy them that you have the appropriate indemnity insurance in place. Part 11 is also mainly regulated by court rules, so it's a very specific kind of area that, you know, I don't think is very appropriate for this room. Now, just with strike-off and restoration, a company can be struck off from the company's registration office, as I said, sometimes by just not getting their filing in on time. Now, the CRO is quite lenient around it, in the sense that if, you know, they'll send you a notification saying your accounts are due, they'll send you a notification saying your accounts are late, and then they will strike you off the register. So it doesn't happen overnight. But when you have been struck off, you will have a period of 12 months to go to the CRO and try to have yourself administratively restored back to the register. It is important that you are an active company if you are out there trading as one. And so that's a very straightforward thing. The only thing really there will be that the CRO will seek to see whether the revenue has any issues with you being restored. Yet again, it's if your taxes are in order, life will be in order. If it goes over for more than 12 months and the Act is now very specific around those time limits, then you have to go to the court and seek restoration. That is much more costlier, there will be more parties involved. So ideally, if by any, you know, and sometimes life intervenes. You know, let's face it, a lot of companies are small entities, they don't necessarily have accountants on, you know, accounting divisions, etc. You know, something happens, you might miss your deadlines. It's not the end of the world, but it is not something that you should be doing unless you absolutely have to. The other difficulty with strike-off, yet again, not applicable to a very small company, but if you are a medium-sized company and you have availed of the audit exemption, you will lose it if you miss your audit filing dates. So it is, filing on time is extremely important. It's just generally good kind of discipline to get yourself into if you are a company or a company director. And indeed, you can actually stay off the register as a struck off company for up to 20 years. You can still be restored up to 20 years. So that hasn't changed under the Act. Part 13 has very little in it, but Part 13 effectively gives the ODCE, which is the Office, the Director of Corporate Enforcement, certain powers to search, enter, you know, come in, look at your records, insist that you produce books and so on and so forth. If there is an investigation that there is reasonable cause to assume that a company law offence has occurred, we do have an enforcement body in Ireland who will and do have the power to enter, investigate, etc. So this part provides their powers. Part 14 then is compliance and enforcement. And it is important, I suppose, that the defence of acting honestly and responsibly is no longer sufficient. So it's not just good enough to kind of go and say, Judge, you know, but sure, look, I thought I was doing the right thing. There is, you know, a need to be able to demonstrate that you understand your obligations under these acts. Also, there is now a specific statement saying that if a liquidator has requested that a director cooperates with them with regards to anything that the liquidator reasonably needs, the court, you know, you must demonstrate that you have cooperated with the liquidation. So you can't be seen to be the difficult person who's kind of clinging to the desk, you know, fighting for it to be removed from the premises. You may know that under company law, a director can be restricted from being a director. And these are lesser offences. So these are situations where a disqualification hasn't been given, but you've basically been, you've been told, look, you're not going to be acting now as a director for a period of 2 years. You're kind of put on a bold step, if you like. However, the Act does provide that if a company, for whatever reason, insists on keeping such a director as a director, they must then put a bond in with I think it goes with the CRO. I'm not quite sure where it goes actually, but it's a minimum of 100,000 bond. So that is to basically say, yes, we have a restricted director acting as a director. However, we're putting a bond of 100,000 to say that this director will not do anything untoward. And that bond obviously then would be used to rectify any damage. And also, there is a new thing, and I just mentioned this to Femi there very recently. There is now a possibility of taking an administrative undertaking instead of, so this is a situation where the ODC is indicating to you that they're going to start restriction proceedings. You could agree with them administratively to not act as a director for a period of time, to accept the restriction without the court involvement. So that is something that is provided for in the Act. We're going to have to see how that works out. I said to you in the onset that we have now clear categories of offences. So it's, you'll see the categories are set out in 871. However, as you go through the Act, if you're looking at, say, share capital, whatever, it will then, in each section where there is an offence, it will say this is a category, whatever offence it is. So category 1, indictment can result in imprisonment for a term of up to 10 years and or €500,000 fine. Now, indictment means it's a circuit court. All these could also, category 1 also can be done summarily, as in district court. Then it's 5 years, and then you have 6 months imprisonment or a Class A fine. A Class A fine is something that the Department of Justice regulates under the 2010 Fines Act, and that currently is €5,000. And category 4 is a Class A fine. So a lot of the kind of failing to file or failing to do notifies, those kinds of offences which aren't necessarily as detrimental would come into the category 3 and 4, whereas category 1 and 2 offences are ones where usually there is some dishonesty or active not being good involved. Okay. So Part 15 then provides for the regulatory bodies, and I'm not going to spend too much time on these. The most important for you is the Registrar of Companies, the CRO. As I said, it's out. They have a very useful website. You can now electronically file with them as well, which makes life a little bit easier. They provide a lot of information. IASA is the Irish Auditing and Accounting Supervisory Authority. They regulate accountants really, and they will also have some supervision around liquidators. The Director of Corporate Enforcement is the ODCE. They are the enforcer. Their job is to ensure that if a complaint is made to them that company law has been breached, they must investigate to see whether that's the case, and then it is a matter for them to decide whether they prosecute or not. The Director of Corporate Enforcement has the power, just like the DPP, that's the Director of Public Prosecutions, to prosecute. So they have the power to take individuals to court. And then you have the Company Law Review Group, which is a statutory body set up of interested stakeholders who inform the Minister of the company law, its operations, and make recommendations. So these still continue, and they're provided for. DAC. So remember, the DAC is what used to be is the current, the last week's private limited company. So the rule of minimum 2 directors remains. You still have your 2-document constitution because you must have your objects clause. You must have authorised capital, and the only way you can dispense with holding an AGM when you're a DAC, this is the need to come together in a room like this and discuss matters, is if you are owned by one person only. So we have actually rationalised that one person does not have to come together with themselves anymore. So that's now specifically stated out. What a DAC can do, it can list securities, and that is something that the simplified company type is not allowed to do. And currently, any existing company that was a private company limited by shares is a DAC, okay, until the transition period is over. And here's where the Act now gets a bit more interesting. We're now in what I'd call the Volume 2. So effectively, you have all gone through very briefly and very quickly through the Part 1, Volume 1. So say you're looking at incorporation of a DAC. You will open Volume 2 and you will open Part 16 and you will see it will deal with incorporation. Effectively, incorporation that is set in Volume 1 will apply to a DAC unless it is specifically disapplied, modified or supplemented in Part 16. So if you are a DAC company, you must read Part 16 of Volume 2 in conjunction with whatever relevant part you're looking at in Volume 1. Does that make sense? Yeah. So it's not that you can just look at Part 16, because otherwise you think all these other company types are marvellous. They're only about that much information. But actually, you need to, first and foremost, is you go into Volume 1, you'll see incorporation. You look at the rules there, so you'll see the Constitution, yada, yada. Then you go to the DAC bit, and you will see a chapter there called Incorporation. And you will see certain provisions are disapplied. That means you ignore them entirely. Then you might see something is modified or supplemented, and that is how that specific thing applies to you because of your company type. Now this happens over in PLCs, in the unlimited companies and everywhere else. So this is where you need to, am I up?
No, it's just maybe if you give them an example of a company that can go under DAC and private limited.
Okay, well, as I said already, a DAC could be a company that has its objects clause is to provide financial services, or it sells insurance. If you're doing any of those things, you have to be a DAC, because insurance regulations would say you must have an objects clause. It's not company law that's saying it, it's insurance regulation that's saying it. A limited company can be any type of company. But say for whatever, you have a group of people who come together, they form a company and they say, we're going to sell sheep and that's all we're going to do. That is fundamentally what this company is about. That's what our money is about. That's crucial to all of your members. You might then set up a DAC, because that is all you will be doing then. You're selling sheep and that's it. So that is why a designated activity company is what it is. It is very specific to what it does. Okay? Does that make sense? Yep. And as I said, those who want to list debt securities on a stock exchange. So if you want to do that type of thing, you have to be a DAC. And this is going to be another change that you're not going to see until the end of November 2016. But after the end of November 2016, all company types must, after the end of their name, identify what type of company they are. So you will have Tara Coogan Limited, then you might see Tara Coogan DAC, you might see Tara Coogan PLC, you'll see Tara Coogan UC. So the reality is, as a person dealing with a company, after the November deadline of 2016, you will know what type of company it is. Okay? So that is going to require, if you're in the printing business, good news for you, because all companies are going to have to, during this transition time, when they start issuing their new letterheads, their letterheads will have to indicate the title or the type of company that they are. Now, the PLCs, I'm not going to spend too much time on them. The law is very much as it always has been. Yet again, if you're looking at PLC law, you must then look at Volume 1 and then read Part 17, see if something is disapplied, modified or supplemented, and that is how it applies to you as a PLC. You can list shares on stock exchange and offer them to the public. I think there's only about, there's not many PLCs in Ireland. It's not that big. You must hold an AGM, obviously, because you're a public limited company. And you must have an objects clause. But yet again, you can't rely on that ultra vires doctrine, which I think I mentioned at the very onset. And the minimum issue share capital of a PLC is much higher than it would be for anybody else. Private limited company could be as little as €1, but here it's 25,000. And that's legal requirement. Guarantee companies, I've already mentioned these very briefly, so I don't want to really go into them. The difference with a guarantee company is that it doesn't have shareholders, it has members. So if you are, for example, an owner of an apartment block, you have an apartment, that's usually a unit, and everybody who owns an apartment will be a member of a particular guarantee company. These are very popular for charities, sports and social clubs and apartment management companies. And yet again, the audit exemption has been extended to the company limited by guarantee. And they will be known as CLG or CLG, and I believe that also stands for GAA in Irish, so there's going to be a bit of a confusion there. Nobody picked that up until it was too late, but that's kind of a new thing here. And yet again, they will have an objects clause, and they must have a minimum of 2 directors. So the requirement to have 1 director is really only for the simplified company type. Unlimited companies is effectively, as said in Part 19. I'm not going to go into it purely because I can't see many of you setting up unlimited companies, but you might. Yet again, I'm not here to advocate any specific company type. But there are 3 different types of unlimited company known in Irish law. So you have a private unlimited company with share capital. For example, Dunnes Stores would be one of those companies. You'll have public unlimited company with share capital, and then you have public unlimited company without share capital. And these are kind of a lot of religious, some of the religious organisations, for example, fall into this category. It took me a while to figure out any of these, but effectively the thing that distinguishes these is these companies do not enjoy unlimited liability, or as in, yeah, limited liability. Persons who own the company are personally liable for the acts of that particular company. However, they do not file. We know very little about their fiscal affairs due to that particular reason currently. And they will be identified as an unlimited company at the end of their name, at the end of transition period. So just very briefly, should you miss your transition periods, or should you set up as a company and then in 2-3 years' time decide that that company type does not really work for you, you can always re-register as a new type of company or a different type of a company that is more suitable for your needs, provided that your shareholders obviously agree. So Part 20 provides for this kind of a procedure after a transition period for companies. So you can be a PLC, you can become a limited, you can be a limited, become a PLC, you can come, provided that you adhere to the rules of whatever rules govern that particular company type. External companies, as I said, these are basically companies that are incorporated in the European Economic Area, so that's a slightly larger area than the European Union. Or outside. So effectively, any company that is not formed in Ireland is considered an external company. And we've abandoned the place of business concept, and now if you want to have a presence in Ireland, you will be known as a branch, and therefore we'll have some information about you. And effectively, the unregistered and joint stock companies law remains exactly the same. I did come across a very interesting blog. The internet is a fantastic place for bad information. And effectively, I think if I had read it and believed it, I would have taken all my money out of the Bank of Ireland and run for the hills. It was very badly written and badly understood. But effectively, the law governing unregistered companies remains as it has always remained. What we do provide for is a system for unregistered companies who want to become registered companies. That's a new thing that hasn't been commenced as of yet. And Part 23 then deals with, and this is where the Minister is different. This is Department of Finance matters, and this governs areas of prospectus law, market abuse law, and transparency law. And effectively, these are European Union requirements, and they are more related to the stock exchange. It's how you list things, etc. So they're not particularly specific to your simple company type. They're not applicable there. They come with a separate set of offences. So these offences stand outside the categories that we have set out in Part 14. And the reason they sit outside is that they are higher than what we would give. These are European Union has dictated them. And then the investment company area, this is kind of, I suppose, a part that we're hoping will become obsolete over a period of time. The investment company area is one where there is constantly reinvention of new types of investment vehicles and other types of thing. So this only applies now to what are known as non-UCITS. So UCIT regulations apply to certain investment companies. And I know this is kind of an area, if I start talking to you about it, I will lose you all, so I won't. But effectively, if you're an investment company, Part 24 is your area of law. And then Part 25, the final part, you'd be delighted to know, is the one where we had to put everything that we couldn't fit anywhere else. Didn't neatly fall into examinership law, didn't neatly fall into specific company type. So it is important to get slightly familiar with the miscellaneous provisions part as well, because there could be some surprise there. I doubt if there is. Effectively, it provides for things like insolvency proceedings across European Union. It provides for some exemptions for the use of unlimited or DAC behind your name. Those wouldn't be applicable to normal situations. There are certain insurance-related provisions, etc. there, but just so that you're aware that there is also a Part 25. As I've said, the transition period will end on the end of November 2016. And all non-converted existing limiteds, which now are deemed to be DACs, will become limiteds at the end of the transition period. However, a company can immediately go to the CRO, and I understand this week already 40 companies have sought to convert to whatever type. So the process is already working, it is already in place. And I mean, obviously the CRO has indicated to me that there might be some hiccups, you know, some learning problems, but as I said, they have started the process. And this is very important for the companies limited by guarantees and UCs, but they have to change their company name. But that's yet again. So all Irish registered private limited companies will have to change legal form post-enactment of the 2012 bill, which is now the 2014 Act. So there is no status quo option. All guarantee companies and unlimited liability companies will have to change their name. And current private limited companies governed by the designated activity company, so Part 16, until they convert during the transition period. And just a reminder, the transition period, whilst it is 18 months, you must start the transition after a period of like before the 15 months is full. So if this is something you need to do it now rather than later. Don't leave to the last minute. So here's the transition periods for you again, and I think I will stop here.